Thanks, Tom. Jan and I will be the speakers on this webinar. My background, for those of you not familiar with me, is that along with Tom, I am the co-founder of EDRM, and then more recently, Apersee. I was in private practice 16 years before moving over to the consulting side, and these days focus almost exclusively on eDiscovery and related issues. Jan?
Yes, hello, George and Tom. Yes, my name is Johannes Scholtes, Jan Scholtes short. I'm the chairman and chief officer of ZyLAB, and I've been involved in many projects where we've helped organizations such as the UN War Crimes Tribunal, but also law enforcement and many corporations around the world to bring eDiscovery in-house. And my background is a technical background, and I'm also partly professor of the extraordinary chair of text mining at the University of Maastricht. That's it for me.
Okay, thanks, George and Jan. Before we get started, I'd like to go through a few logistics. First of all, you'll see at the top of your screen there's a question button. We like on our Apersee webinars to have the audience participate as much as possible, and so this is your opportunity to pose questions to the panelists throughout the webinar, and we will answer them as quickly and as appropriately as possible. So please do ask questions. Also, to notice that there are attachments that are available for your download that will be available at the end of this webinar after it's posted within a few minutes after conclusion. So you're certainly encouraged to download those attachments for your viewing. You'll also know at the top of the screen there is a Twitter hashtag, #Apersee in-house. And so for those who are Twitter aficionados, please tweet to your heart's content throughout the webinar. Also, to just remind you that this webinar is recorded and will be posted within a few minutes after conclusion. Links will be available on Apersee, on the Bright Talk channel, and on the ZyLAB website. Throughout the webinar, and we have had questions from time to time about sound. Any sound issues are actually a factor of your internet connection, your browser, or your computer. And so if you have any difficulties, please try reconnecting. And then finally, you'll notice at the top of your screen there's also a ratings button. At the end of the webinar, we'd appreciate it if you took a few moments to rate the webinar and let us know what you think. So with that, let's get started. George and Jan.
Well, thank you. And again, please do send in your questions as we go along. It will make for a more interesting and fruitful webinar for all of us. We want to cover basically two broad areas in this webinar, the overall focus being the bringing of electronic discovery in-house. One area we want to focus on first is just that, the narrower topic of what to do about bringing electronic discovery in-house, when, why, how, those types of things. The second thing we want to do then is to look at what for many corporations can be the next step, which is to expand those capabilities, the eDiscovery capabilities they've brought in-house, expand those beyond traditional eDiscovery activities and use them as well as a way to do a better job of governing the organization's information. So to start, we'll start with what is, we suspect for many, a fairly familiar slide. Because if you're going to talk about bringing electronic discovery in-house, it helps to have some sort of framework to use as a starting point. And this is the framework we will use as we work through our discussion. If you're not familiar with this framework, go to EDRM.net. There are thousands and thousands of pages of content up there relating to this and working with this diagram. But we're going to start at the beginning or the left-hand side of the diagram here for our discussion and focus on the information management piece of the diagram as a starting point. Because especially when we're talking about bringing electronic discovery in-house, this is in many ways the beginning of all of it. And as you think about bringing in eDiscovery in-house, here are some of the questions to focus on. And I'm going to start right away with interrupting myself and ourselves with the questions we're getting online, because I see one of the questions is, can you give some examples of some law firms that have brought eDiscovery in-house? And I'd like whoever posed this question to follow up on the question, because there are two ways that we could be looking at that. One is law firms bringing eDiscovery in-house, just as corporations bring eDiscovery in-house, so that they can better address their own eDiscovery challenges, as in, for example, they get sued and need to put litigation holds in place on their email messages. The other way is law firms bringing eDiscovery in-house in terms of bringing in-house the tools and capabilities that they can then use to better serve their clients and their clients' eDiscovery needs. And we can touch on both of those. Jan, either you have comments on either one of those right now, and then we will come back to our slides.
Yeah. No, both are very interesting. What's most important, what we see these days, is that parties want to have control over the eDiscovery data, and you can have control by getting the data and put it on your on-premise software, but you can also get control by renting or organizing or managing a hosted solution where the data resides somewhere else. But by having control over your data, you have much better control over the process. And of course, you can also use all kinds of content analytics, text mining, and other technology-assisted legal tools that allow you to improve on several parts of the process, from collection, identification, and all the way to legal productions.
And I think a lot of this is really about one core concept when we think about information management in the context of electronic discovery. And that core concept is that if you do not have your electronic house in good order, good luck finding anything in it. Chances are, if it's not in good order, you don't even know how many rooms you have, to say nothing about what those rooms might contain. And that takes us to these very four questions, which are just some of many that serve as the starting point as you think about how to get that house in order. So the first one, what electronically stored information do you have in the first place? What do you see corporations grappling with as they look at that in the context of how they can bring eDiscovery in-house, Jan?
Yeah, well, what we see is that there's a couple of problems in the information management part. Of course, every good organization, whether it's government or corporate or law firm, wants to know what they have and needs to be able to answer these questions. But what we see happening is, because of the ongoing exponential data growth, but also the fact that more and more data is no longer within the direct control of an organization. It can be outside anywhere. It can be outsourced. It can be in Google Docs or any kind of social media or cloud storage area. Also, we see formats changing all the time. There's all these different electronic file formats. There's more and more multimedia, audio, video, which are very hard to search formats. And there's also more and more legislation, both national and overseas, that makes it harder and more difficult for organizations to be compliant with different legislations. And even if we see that even good organizations that try seriously and sincerely try to have their information management part under control and invest in it. Even those organizations, because of the ongoing change of the nature of data and the exponential growth of data, always have data which is outside of their control, and therefore they always need to have some kind of solution to work with this less controllable unknown data. And another great example are, for instance, legacy systems. A lot of companies have acquired other companies, or companies have shut down divisions or organizations, and people leave, and the data is still there. And all of this data can also become part of eDiscovery investigations, regulatory investigations, etc. To kind of answer your question.
Yeah, and how to address this, I think, falls on a spectrum. And at one extreme, you look to somebody outside the organization to take care of all of these issues for you. You bring in a group, have them try to assess what data you have, where it is, what it looks like, who's got access to it, why it was generated, all of those things, and present you with some sort of précis or summary of all of that, with the hopes that you can figure out what to do next. At the other end of that spectrum, you attempt to do all of that internally, and of course, in the real world, it's usually some blend of those two. What I see is that organizations that are in a position to at least control and to be in charge of that investigative process, figuring out what they have, where, when, and how, all of that, and especially organizations that play a major role in carrying out those activities tend to do a much better job of actually figuring out what they have for a house and being able to figure out what is where so that they can then move on to the next stages.
Yeah, no, and you can see that, there's different tools that you can use. You can use technology to automatically identify where all these resources are in your network, but there's a lot of data which is not automatically discoverable. So you do need to organize workshops, and you do need sometimes these external third parties to help you find where all your stuff is.
Which takes us to the first sort of active step in this process, trying to identify what information you have. And then here again you have that spectrum of who's doing it, internal versus external. What tools do they use? Ones that you have, the ones that you bought, ones that you rent, ones that are installed internally, ones that are available through the cloud or some other external location. And again, there are benefits and risks to both of all of the approaches across the spectrum. One of the benefits of trying to pull these capabilities in-house, and we'll give you just a screenshot of an example of one of these in a moment, but one of the benefits is that there's at least a theoretical possibility that as you move these capabilities in-house and take greater control over them, you can do several things. One is you stand the chance of reducing costs, and you can reduce the costs in several different ways. One is that if you bring in people from the outside who do not know what you do and how you do it, they have to start from scratch in all of this. They have to learn who you are, what your systems are. That can take a considerable amount of time. If you have people internally or who are managing and running that process and either working with others internally or working with folks from the outside who are regularly involved in that, you reduce those startup costs, which can be considerable. Second is that if you have people internally involved, they're going to have a much better opportunity to really know where the skeletons are in the closets, as it were. They will probably have access to information that outsiders do not get access to, and they may have an institutional or their own memory to draw on to help with that.
George, we've got a follow-up to that original question. You asked for clarification, and the questioner says they're interested to know law firms that have software and solutions installed in-house in their IT infrastructure to help their clients with eDiscovery. In other words, they are eDiscovery services providers in-house that used to be provided by outside. And so they're asking to name a few names, law firms by name, that market and offer these types of services.
Okay, Jan, do you want to start with any names, naming names here?
Well, I think you're better at naming names.
Okay.
I'm under all these NDAs,
yeah,
I'm not allowed to say.
It's actually a bit of a challenge because there are firms who use tools in various different ways.
Mm-hmm.
To name some example of firms that, at least as I understand it, have pretty substantial in-house capabilities, and those in-house capabilities fall into three broad categories, and nothing new in these three broad categories, but all three important. One, the technology they use. They're using technology, whether it's their own or whether it comes from someone else, but they are the users of that technology. Second, people. They've got folks who are well-trained, experienced, and have a good sense of what they are doing. And third, processes. They're not just pointing someone to a tool and saying, go figure it out. They've got workflows of various sorts in place. So to throw out a few names, and these are just ones that come most immediately to the top of my head, Fulbright and Jaworski. I'm not sure what tools they currently use. I know for a long time they were using Recommind, among other things, but there's a whole array of tools, I'm sure, that they have in their disposal, and a fairly substantial practice group focusing on electronic discovery. Littler Mendelson, one of the few firms I know of that has a number of partners who are dedicated to working on electronic discovery, supporting their attorneys in who knows how many offices around the world. DLA Piper, with a few groups, a few individuals, Browning Marine, for example, very well known, who help guide what the firm is doing and what tools it's using. Voorhees Seder out of Columbus, Ohio, where they have got tools they're using internally. I forget what they use for processing, so I'm not going to name the wrong names. And then review tools as well, where they are running and managing the tools and watching that process. Seyfarth Shaw is another example, and I could go on for a while. Those are just a few of the examples. The commonality there, and it's an important one, is that all of the firms I've mentioned in various different ways have focused on those three things I've talked about. One, having in place good, solid, well-trained, experienced people who are given the opportunity and the latitude and freedom, to a certain extent, as much as you can hope for in a law firm, to really move these capabilities along and have them increasingly become part of the service the firm offers and not something that's done by one or two attorneys within the law firm. Second, an investment in technology, and not just the technology itself, but an investment in the infrastructure, so not just the software itself, but an investment in the infrastructure to run that software, whether it's an internal infrastructure or a cloud-based infrastructure that they maintain themselves, or a cloud-based infrastructure or something similar that someone else maintains. And then third, the time and effort necessary, putting in the time and effort necessary to develop the processes and the procedures so that they can make good, that these people they have can make good, effective use of the technology in place. And all of those considerations come into play not just with law firms, but with any organization that is attempting to bring eDiscovery capabilities in-house, whether for their own benefit or as part of the services they are delivering to others.
Yeah, no, I fully agree. And what you see more in the corporate space is larger focus on the information management, identification, and collection, where most of the systems that law firms have in-house. They presume the data is already collected to either hard disks or to forensic formats, and then they kind of start with the processing all the way up to the legal review. And most law firms still outsource the processing part, and they focus completely on the legal review. So we see, and the legal production, but we see a major change in this market, which started 2 years ago, where there's a huge interest from especially corporations bringing the whole eDiscovery process and at least the control over their data in-house. And one of the reasons is that there's a number of software platforms that are used by almost everybody. So there's like a limited set of solutions, and they all have a very similar feature set, and they all, lawyers and law firms are used to working with these platforms. So what we see happening more and more is corporations or government organizations hosting data, and then having law firms access that data from remote locations, and then do the review on the platform, which is owned and managed by the party who also owns and manages and where the data originates from. And that's where we see the biggest gain in interest in bringing eDiscovery in-house.
So what are the, I've seen some pros as well as cons to corporations attempting to direct the processing themselves and handle the hosting themselves. What are you seeing?
Well, what you see is there's different types of cases. We have many clients that have 600 to 1,000 lawsuits every year. Now, most of these lawsuits are pretty small. They involve maybe 20, 40, 50 gigabytes of data. They're either HR related or other types of lawsuits. Everybody knows how to deal with them. And these are typically the cases that organizations with enough resources and with enough knowledgeable people, and of course also with templates and best practices and people that know what they do, and whatever they do, they also keep it and make it defendable. Because that's the most important in this application. You can try to bring technology in-house, but you have to be able to explain how technology works, and you have to defend it in court against any acquisition made by the opposing party. Now, organizations do that, that have those capacities. We see that they're very, very successful bringing these easy cases in-house. And also, we as a provider of software for in-house use, we've always focused on not only developing and providing software, but also provide a template set and a best practice methodology together with the software, so you know how to use it. Now, what we see is that everybody sometimes has these really what they call nasty cases, and every organization, especially a large organization, have a few of those, every year. And what we see is that typically for those cases, or for very complex international cases, or for very, very high-profile, legally complex cases, that's when organizations go to either an external party, they outsource the case, or what we also see happening is that they do not have enough capacity in their in-house systems to also run the data for those cases, and then what they do is they rent capacity. We also offer our solutions in SaaS, in the cloud, in a private cloud, and if they need more capacity for particular cases, then they can rent additional technology and additional resources, and also including professional service resources and other resources that can help them to process the data and make sure they make all the deadlines. So it's really this mix that we see with organizations, but most important is that organizations try to keep the control over their data because they know if they turn the data over to other parties, there's always the risk that you get unexceptional or unexpected high bills. You cannot do other analytics on your data. You're limited in what you can do from a point of view from early case assessment. You cannot use the data in the way you may want to use it to try to achieve an early settlement, which is what a lot of corporations try to do. And that's a major change in the market with a few years ago.
We have a quick question
we
here
have a question
about
here.
how you feel about law firms doing data collection.
There are so many ways to respond to that.
Yeah, well, most law firms.
Different takes.
Yeah, now most law firms, what we see is they just use people, specialized people, service bureaus that go on site and do these collections, or the corporations do it themselves.
Yeah, and what I hear when I talk with law firms is that most of the law firms I talk with are hesitant about doing collection of electronically stored information themselves. And I think that's rather intriguing because there are basically 4 forms of information we're dealing with in discovery. Electronically stored information, of course, but information from people's heads, information on paper, and information stored, if you will, in tangible objects. And historically, law firms have taken the lead on at least the information that is in people's heads and the information stored on paper. They're the ones who have handled the collection process, sometimes using others to help them in what are often considered more ministerial roles. When it comes to electronically stored information, however, they tend to pull back and say, no, that's not something we are going to handle.
Yep.
They give different reasons for it, and I see yet others. I mean, the most frequent reason I hear law firms give is that they do not want to have to put their people on the stand to testify about the collection process. I find that somewhat intriguing because apparently they have no such concern when it comes to the collection of information from people's heads or the collection of information on paper. I think probably, and Jan, you probably have good insight into this, the bigger reason why law firms are hesitant to take the lead on collecting electronically stored information is that many of them don't feel that they have the people, the processes, and the technology in place to do an adequate, appropriate, and defensible job of the collection.
Well, it's also not economically sensible because it's like type of work that comes and goes with very, very great difference in capacity that you need. If you're going to do a collection and you're going to use forensic tools or you're going to image hard disks, you need to send somebody somewhere or maybe all over the world. You need like teams of hundreds of people and collect all this information, and then the rest of the month these people may have nothing to do. So it's really something you wanna insource. Or you want to outsource and then have somebody else do the work and just pay these people for the type of work they're doing. It's very non-frequent. It's different loads, and that's also we see the same with processing. Something that law firms do all the time is review and production. So that's really the most sensitive and economically valid thing to bring in house. But even processing, you need certain moments you need a lot of capacity, and then in the other moments you don't need that much capacity. But on the other hand, if you are a corporation or you're a government organization and you have 600 lawsuits a year and your IT department has 2 or 3 people constantly collecting information, and if you do not need to do forensic collections, and you can also collect directly from the repositories and use software such as we have, then you can completely automatically, and also at night when the network load is not that large, or in the weekends, you can automatically collect from particular locations, as we'll show in a second. You can also do dynamic recollections, which allows you to postpone tape recycling, and so there's all these other great things for corporations and the benefits to bring eDiscovery in-house, and it's really there where we see the benefits in the business case, not in the law firms.
And that brings
question.
up an important point in this, which is that it's not only a question of the law firm's capabilities, but the client's capabilities as well. So that if a law firm is working with a client that routinely does its own collection work, then it makes sense, provided that that's done appropriately, to leave that in the client's hands. On the other hand, if the law firm is dealing with a client that has never faced these issues before, that client is probably looking to the law firm for guidance, if nothing else, whether the law firm actually engages in the collection work or hires it out to somebody else.
Question that we have right now from the audience is, do you see the corporations or service providers doing more targeted collections versus?
Yeah, no, that's exactly what I just said.
Yeah. Yeah, and is this generally accepted by the opposing parties and investigative agencies?
Yeah, what we see in general is that if there's like blood on the wall or there's a criminal investigation, then you want to make forensic images. If this is not the case, this is a civil and you're dealing with a civil case, then targeted collections are completely acceptable. What you need to do, of course, is use specialized software that creates a chain of custody and that creates hashes and that makes a full logging of when it's collected and stores a hash value for that particular file at the moment it collects, and so you can trail back the whole chain of custody. But then there's absolutely no need to make forensic images of everything. You can just go to a particular mailbox, collect a mailbox, collect certain emails from mailbox. You can even, if you have full text index, file share or SharePoint, or you use other search technology, you can collect by using this search technology. Or what you do is when you collect, you filter the content directly against keywords, so you do keyword-based collection. And there's a lot of possibilities here to save like the very high cost of forensic images, and especially when data collections are getting larger and larger and you have all these terabytes, it takes forever to forensically image a terabyte or a petabyte of information, and really you don't want to go there if it's not essential.
And it's also a function of the type of information you are dealing with. While a forensic image of a hard drive might make sense, depending upon the type of hard drive. If you've got a solid-state hard drive, you've got a different set of issues. A forensic image of a relational database might be less valuable as a forensic image because you don't have the same benefits.
And it's also getting harder to make forensic images. If you have like Hyper-V installation or virtual machines, or you have these systems that don't have hard disk anymore but do everything in memory. How do you make a forensic image of those? And then a direct targeted collection is really the better way.
And then how meaningful is a forensic image if you move over into the world of big data?
Yeah.
And you've got multiple data sources feeding to a system that is dynamically changing what it displays, depending upon what's in those data feeds.
Yep.
And the more complex those components become, I think the more that suggests that the corporations that have the wherewithal to do so ought to be looking at bringing these capabilities in-house. I'm going to jump a bit through our in the slides and leap over some of the ones we had in place to move over to the governance side of things and then pull back a bit. And what we're showing up, or will show up here in just a moment, is an image taken from the EDRM's information governance reference model diagram, which folks at ZyLAB and others have helped put together. And this is a different way of looking at all of this, not one focused so much on electronic discovery, not really focused on electronic discovery at all, but rather on the larger world of information governance. And what I'd like to jump to now is Jan, your thoughts on what corporations that have decided to bring eDiscovery capabilities in-house and have had some experience with the types of things we've just been talking about, what those corporations can do to then take those tools and techniques and move them out into the much larger world of information governance.
Yeah. No, and that's actually a very interesting development that we see happening, because once organizations have invested in eDiscovery software and they have trained their people and they're familiar to the best practices of processing and collecting and reviewing data, that's when we see many organizations, also because eDiscovery, sometimes you're very busy, the other time you don't have that much to do, so there's a lot of room from a time and capacity point of view that these departments can also start looking at, being a little bit more proactive, and we call that like big data risk management or big data risk assessment, or we also have a white paper which we call the dark side of big data, where organizations start looking for the risks that are in their data collection, and this can be anything from removing old data or just knowing where your data is, but also, for instance, finding data which has been misplaced in the network and has the wrong security access, and as a result, people can have access to it, or data can leak, and you can either violate privacy laws, data protection laws, you can be a victim of intellectual property theft with all the new patent laws. Maybe information gets into the public when you're still working on filing your patent and you're syncing your patent application chances. All of these things are very valid business cases where organizations start being a little bit more proactive, and you can also look at export controls that are violated, FCPA bribery risks, fraud risks, and try to find these type of risks and deal with them as early as possible, report them if needed, and know that what's going on, know what's in your data, because these days risk is in your data, and it's getting more and more data, and organizations really are becoming more and more aware of these risks, and we see organizations having vice presidents of legacy systems. We see organizations having vice presidents of data risk analysis. Gartner wrote a great report about the need for a chief data officer, and this is a major change, and this is a huge benefit of bringing the whole process in-house.
One of the use cases that, using that term loosely, that you and I had talked about before, Jan, was using the tools and techniques put in place for electronic discovery as a better way of identifying what data retained by an organization really can appropriately be disposed of.
Yeah.
How would someone go about doing that?
Yeah, we call that defensible disposition, data disposal, or legacy data cleanup, and this is a great moment to do that. If you're, for instance, if you're considering a cloud migration or you're consolidating your data centers. One of our clients, been an eDiscovery client for a long time, and they're now consolidating many data centers from different plants nationwide into a new cloud solution. So when they're collecting all this data, they're also at the same time assessing the content of the data, and then they're determining instead of creating a legal production, they create reports, and the reports contain, okay, how much data do you have? How old is it? What is the topic? What department is it related to? What type of data? Is it HR data? Is it data containing personally identifiable information? Is it data related to clients? Is it data related to our intellectual property? And it's very easy to determine these type of the content of a document and assess the content automatically. Computers can do that with very high accuracy these days by using text mining and other artificial intelligence techniques. And then you can generate reports and present an overview of the content of your data, and then it's up to the business owners or legal to determine what to keep and what to delete. And of course, that has to do with your regulatory obligations. It may have to do with your internal policies. It may have to do with policies from your clients. Maybe your clients insist that you keep certain records, but this is where a cooperation between IT and legal and records managers, if corporations still have people in that job, and that's one of the problems. Most organizations don't have records managers anymore, or at least not people that actually are filing. And that's why we see a change where records managers used to file documents in the past in advance. We now see that at a certain moment organizations get a little worried, and what they do is they do kind of records management after the fact. So every year or on a regular basis they assess the content of their data, and then whatever they need to keep, they keep it, and everything else they just get disposed of.
What sort of reductions might they be looking at if they can turn these?
Oh, it's huge. It's huge. It's huge. There are so many duplicates. People keep everything. The business people in general keep everything just in case, and we see huge reductions. 90% or more is really not uncommon.
And have they faced situations where they are then challenged on this, where people,
Yeah, no, of course what you need to do is, what you need to do is, of course, if you're under legal hold or there's, a threat of a lawsuit, you shouldn't, start doing these type of activities. You should do them as a normal, ongoing, regular part of your normal business. And because if there's like indication that there may be a lawsuit, and I think you know the case law best, there was one of these cases. Then if you suddenly start implementing and reminding everybody of the retention policies, that's not the way to do it. You need to do it on an ongoing basis, regularly, and run these processes. Now, when you do these processes, of course, you have to document everything that you do. And if you destroy documents, you need to create what we call a statement of destruction, and the person who is destructing the data has to sign off on that, and you need to keep these statements, and that's how you do it in a proper way. But what we did is we see that almost all of our clients, once they've brought eDiscovery in-house, the corporations and the government, at a certain moment they say, well, we want to be a little bit more proactive. How can we do that? And so what we did is we do not only have templates and procedures and best practices for bringing eDiscovery in-house and then do the reactive eDiscovery and fulfill all of the requirements under the Federal Rules, Civil Procedure, and all the best practices under EDRM and other standards. But we also have templates and a methodology to help them to clean up and assess the risk of their old data. And we created this 10-step process where it's very easy for our clients to do this with exactly the same software. It's just a little different process. And then, of course, you also have to do what you bring up now. You also have to do processing. You have to analyze data. You also have to review the quality of your automatic classification. But instead of classifying for privileged, responsive, and confidential, you start classifying for, well, I want to keep this, I want to dispose this, this has to go to my HR department, this has to go to my client records, my client contracts, etc. And then the analysis is more like a risk analysis, where you're going to look, are there risks? Well, what risks jeopardize our strategy as a company most? Is it bribery? Is it privacy violations? Is it fraud? Is it just, the collection of data, intellectual property theft, intellectual property leakage, etc.?
Well, we've got a question from an attorney in the audience. They worry about the privacy and risk issues and poses a hypothetical. It says, let's say a wife brings to her law firm the husband's laptop before filing a divorce. Can the law firm image and review the data on that computer without concern about privacy or other legal risks? How do law firms deal with this?
You want me to answer this? I'm not a lawyer. I can't answer this.
And I'm not quite sure how to respond to something like this. I can give sort of a quick gut response, and I'm sure I'll be second guest or third guest on this. But a wife intending to file for divorce brings to the lawyers she has hired her husband's laptop, her husband's wallet, her husband's day timer, anything like that. I suspect, and this is not an area of law I know, but I suspect there are some issues with that, and I don't think the issues have to do with whether the information happens to be in electronic form.
That's right.
As opposed to some other form.
Well, and what we're talking about here is like corporations, and there's a lot of privacy laws, but we're talking about corporations. The data is owned by the corporation. We're talking about corporate data. And even in France, even in Germany, where privacy laws are very strict, if you have suspicious that something is going on, something is not right, then even in France, you can do whatever you want, but you have to say what you're going to do, why you're going to do it, how you're going to do it, and when you're going to do it. And then even with the unions in France or Germany, you can investigate whatever data. As a corporation, you want to investigate to see if there's anything which is wrong. Now, as an IT department or as a legal department, of course, you can investigate all of your data by using automatic systems to identify if data has been misplaced. People have ignored data access policies. People ignore, for instance, the fact that you do not want certain personal and private information to be stored in general access areas. And that's the type of applications we're looking for. And that's the type of applications where corporations do have a lot of risk, and they do want to address these risks.
It's by no means a universal answer, but one way of looking at questions such as this one is to take the E off the front of eDiscovery and ask, okay, in a traditional discovery setting, what would I have done? How would I have handled it if I had been the attorney retained by the wife to help her with her divorce, and she had come into my office with her husband's diary and his wallet? How would I have handled that? Because it's probably not that much different. Putting the E in front of it in this context, this type of context, probably does not change the calculation and the assessment that you go through.
Now, having said that, what I hear a lot in this context is that in civil lawsuits, such as a divorce, there are spouses that do require all of the corporate email from the other spouse because they suspect that there has been communication with parties that they have been cheating with. And this is something, for instance, for schools and universities and corporations, which is a huge load for the IT department because they get a lot of these requests, especially organizations with a lot of employees. They get a lot of requests for data, and all of these collections are like maybe 10, 20 gigabytes, and I know of many organizations that have like several employees on the payroll to address these subpoena requirements and requests, and they save tons of money by bringing eDiscovery in-house and doing the collection from file shares or mailboxes or SharePoint projects and other relevant locations automatically.
And one of the things that some corporations have done, I don't think it's that commonplace, especially in this context, but is to take, again, the same tools and techniques or similar tools and techniques and look to see if there are more problems like this, whatever the like this is, out there. Okay, we've started to face issues with this product that we've developed. And it may be allegations of a manufacturing flaw, for example. Well, can we take some of these investigative tools, go out there and look to see not just what we can find out about this product, but whether perhaps similar products, not a target of this lawsuit, might have issues with them, and whether there's something that can be done to address the problem very early on, rather than waiting until it becomes a larger issue. And that's looking for the gaps, that's looking for the anomalies, looking for the outliers, looking for the things that don't fit what you would hope the pattern would be, or things that fit an aberrant pattern that you develop. So you create a story, and then you look to see whether there's data that matches and supports, or that conflicts with and refutes that story.
And what's very interesting is that this has been done forever by law enforcement and intelligence agencies. You know, the technology is all there, and we see more and more corporations. Of course, you have to embed this within your policies, and it has to be compliant with privacy and other regulations. But this is absolutely what a lot of corporations are doing. And sometimes what we see where most organizations are really interested in these days is starting to understand what they have. That's already what a lot of organizations have no clue what they have. They don't know. Some of them don't even know how many hard disks there are, how many servers are there. You know, what is out there? Why is it there? Why are we still keeping it? And by knowing what you have, you can start asking these other questions. Why do we keep it? Why is it there? And then another question would be, what's in it? And then another question would be, okay, what's the risk? You know, with what type of violation may be in this data? Can we keep all this data? It's really defending your big data and defending your data in general, or defend yourself against your data if you look at it from the other side.
And there really are there is a wide range of possibilities in terms of things that can be done. Once you start to say, how can I take these tools, these techniques that I've put in place for a very targeted purpose for dealing with electronic discovery, and broaden their usage? So yet another example is in efforts to identify contracts and agreements the corporation has with other organizations. Not everyone does a good job of managing and maintaining all that information, and you can take these tools, take these techniques, and with some creativity and some care, do a much better job of finding out where these types of agreements are squirreled away and start to gain more control over that, figure out whether you are in compliance with them or not, whether there are issues they suggest that you weren't even aware of, and the list can go on and on. So saying the list can go on and on, what other examples have you run into, Jan, of people taking these tools, techniques, and pointing them in other directions? So their information.
Yeah. Well, what is most logical for corporations is to bring of course the information management, the risk analysis, the defensible disposition, but also the collection and identification and the processing in-house. But what we see happening these days is that there are also more and more corporations that bring the review in-house and the legal production, and they're actually starting to be their own service provider. Because there's a group in the company that hosts the legal review software and the legal production software for all of the various law firms and forensic accountants that need to have access to this data. And that's really the latest of the development of bringing the eDiscovery in-house. And it's a part that, you know, up to a couple of years ago, it was really the left side of the EDRM which was being brought in-house. Now we see that also the right side of the EDRM is being brought in-house. And I've talked to many law firms that are also a big sponsor and a big in favor of this development, because they no longer have to invest in all these tools. They use the tools that a client provides to them. They don't have to organize all these contracts with service providers. They don't have to transfer data between different locations. So there's less risks that something goes wrong. So you don't need all these complex procedures. and they can focus on what their core business is, providing legal assistance and legal services. And it's not directly an answer to your question, what other applications have you seen, but it's part of the eDiscovery process, what you would not expect to be brought in-house by corporations, but we see that this is actually happening as we speak.
I suspect we're going to see more of that, corporations bringing review and analysis capabilities in-house. Yep. As the current computer-assisted review or whatever, predictive coding car, whatever you want to call them, as the current crop of those technologies improve and as new ones appear and as people begin to understand them better and become more adept at using them, because what that means is that a corporation who has a relatively small number of people with very deep expertise whom they can make available to help put together the review structure, if you will, and the analytical structure, those people can use those tools and very quickly start honing in on the things that are likely to matter most, and do it in the context of a larger understanding of what the organization does, where it's been. It's not to say, I think, that you push the law firm aside entirely. There are
you still need to use. You need a law firm for specialized topics. For you still need to. You never have enough review capacity to do the whole everything yourself. You will need to have additional capacity, and that's really where external law firms can help. But if you have like these standard HR cases that all get settled, you know how to do that, and you know how to deal with those. Why not do these in-house?
We have just a little bit over 2 minutes left, so just want to remind the speakers that if you'd like to get your last-minute comments in, and we'll wrap it up.
I'd like to thank you guys. Well, what we see, we really see this. There's been a major change, and we really see this happening. And what we also see is that with the right modular eDiscovery software, you can really save a lot of money. In most cases, the return of investment of these systems is just one large case, but also if you have like many small cases, this really helps you. We have clients that almost every week we sign new contracts with companies that bring eDiscovery in-house, and they tell us what a great return of investment they have. And then there's all these other great things that you can do, like what George said, legacy data cleanup, defensible disposition, data risk analysis projects, and you're much more in control of what's happening. And if you do bring these processes in-house, make sure that you do not only buy software, but you also get software including a set of templates, so you can. I think, George, didn't you call that faith-based eDiscovery? I think that's what you want to avoid, right?
So you're not engaged in faith-based electronic discovery, where you just take it on faith that what you're doing is what you need to do, and what you're doing is being done the way you need to do it.
Yeah. And that's
parting suggestions, which are in some ways my standard ones in these types of situations. First, if you are in-house, and you have not brought electronic discovery in-house, but you're dealing with a fair amount of it, roll up your sleeves and try bringing some small piece of it in-house. Start small so that you can make your mistakes small, but start, because if you haven't started, you'll never actually complete the process. If you have brought eDiscovery capabilities in-house, but are not using them to help you meet your information governance challenges, repeat what I said above. Roll up your sleeves, get started, and so on. If you are at a law firm and looking at what your corporate clients are doing, I think you are much better served trying to help them figure out how to make more effective use of the technologies themselves than you are trying to convince themselves that really that work ought to stay only with the law firms. There are certainly circumstances, and many of them, where corporations do not have the wherewithal to bring these capabilities in-house, but there are many other corporations who do, and will be considering it if they haven't already, and there's no reason to fight that if you can work with them on that to their advantage as well as yours.
Okay, well, thank